Hey, Mr. Danson, you know what's cool?
No, what?
Gay marriage.
Cool.
Obergefell versus Hodges was a landmark court case. On June 26, 2015, SCOTUS ruled that states do not have the right to ban same-sex marriage. LGBT communities nationwide celebrated joyously at the result of this case. This is its story.
Loving v. Virginia was a 1967 case that was later cited as precedent in the case of Obergefell v. Hodges. Mildred Loving, a black woman, and her white husband Richard were sentenced to a year in prison in Virginia for wedding one another. However, the Supreme Court unanimously ruled that prohibiting interracial marriage was illegal. Baker v. Nelson was a 1971 case heard by the Minnesota Supreme Court, which ruled that banning same-sex marriage was not unconstitutional. The Supreme Court later heard this case and established this case as precedent, until Obergefell in 2015. Goodridge v. Department of Public Health was a 2003 case in which Massachusetts became the first state to legalize same-sex marriage on the basis of equality. Hollingsworth v. Perry was a case starting in 2009 and ending in 2013, heard by the Supreme Court. This was a series of court cases finding that banning same-sex marriage was unconstitutional and violated equal protection under the law.
The Defense of Marriage Act, or DOMA, was enacted in September of 1996. It defined marriage as the union between a man and a woman in the eyes of the government, allowing states to refuse to grant marriage license and federal benefits to same-sex couples. Windsor v. United States was a landmark case that actually legalized same-sex marriage, while Obergefell v. Hodges made it national rather than a state-by-state case. Edith Windsor sued the federal government for a refund after Section 3 of DOMA barred her from claiming federal estate tax exemption after her spouse, Thea Spire, passed away in 2009. SCOTUS ruled in a 5-4 decision that Section 3 of DOMA was unconstitutional as a deprivation of liberty of the person protected by the Fifth Amendment.
Now, can you please tell me, what exactly is Obergefell v. Hodges?
This case is an accumulation of 6 lower court cases, representing a total of 16 same-sex couples in Michigan, Kentucky, Tennessee, and Ohio.
The Michigan case was DeBoer v. Snyder. It involved a lesbian couple with 3 children. In January 2012, the couple appealed to their district court, saying that the adoption laws were unconstitutional, and they eventually appealed against the ban on same-sex marriage. The defendant was the governor, Richard Snyder. In 2014, Judge Bernard Friedman ruled for the couple, arguing that the state had no right to refuse the couple of their right to marry. In Kentucky, 2 cases were part of the final Supreme Court case. The first was Bork v. Beshear, which was a case involving 4 same-sex couples and their children ultimately fighting against the ban on same-sex marriage in their district courts. In the end, Judge John Hayburn ruled that Kentucky's ban on same-sex marriage was unconstitutional. The second case was in Kentucky was Love v. Beshear, involving 2 gay couples. The case was eventually merged with Bork v. Beshear and ended with Judge Hayburn ruling bans on same-sex marriage were unconstitutional. The case in Tennessee was Tanko v. Haslam. This case involved 4 same-sex couples attempting to adopt children. The case appealed against the ban on marriage recognition against the defendant, William Haslam, the governor of Tennessee. Judge Aleda Trager ruled that the state could not refuse to recognize marriages occurring in other jurisdictions.
The state of Ohio had the final 2 cases, Henry v. Winslow and the illustrious Obergefell v. Hodges. Henry v. Winslow involved 4 different couples, a child, and an adoption agency. They appealed to the District Court of Ohio to have both parents on their child's adoption or birth certificate. The defendant was the then director of the Department of Health, Thomas Winslow. Eventually, the case was amended to be against the ban on same-sex marriage. Judge Timothy Black also ruled on this case, saying that same-sex marriage should be recognized if it is from other jurisdictions. Obergefell v. Kasich was the primary case. Jim Obergefell and John Arthur were married after the ruling in Windsor v. United States, but the state of Ohio would not recognize their marriage. The couple appealed to their district court against the governor of Ohio, John Kasich, alleging that the state was discriminating against same-sex couples who were married in a different state lawfully. Arthur was terminally ill, so the couple wanted the Ohio registrar to recognize Obergefell as a surviving spouse. While the Ohio registrar agreed that refusing was discrimination, the general attorney's office wanted to support Ohio's ban. Additionally, 2 other plaintiffs were added to the case. David Minchner's case was very similar to Obergefell, as his same-sex partner passed away in 2013. Robert Grunn was a Cincinnati funeral director who wasn't sure whether he could be prosecuted for classifying a legally married same-sex couple as spouses, which may have been considered a false statement. This resulted in the case being amended, and the case became Obergefell v. Winslow, with Winslow being the director of Ohio's Department of Health. Ultimately, through the succession of the director of Ohio's Department of Health, the case became known as Obergefell v. Hodges. On December 23, 2013, District Judge Timothy Black ruled that Ohio's refusal to recognize same-sex marriage was discriminatory.
Petitioners for all cases eventually appealed to the U.S. Supreme Court through writs of certiorari. On January 16, 2015, however, the Supreme Court finally agreed to hear their cases.
It was agreed that the oral argument heard on April 28, 2015 would be on the 2 following questions. Does the 14th Amendment require a state to license a marriage between 2 people of the same sex? And does the 14th Amendment require a state to recognize a marriage between 2 people of the same sex when their marriage was lawfully licensed and performed out of state. During the court case, the plaintiffs were represented by civil rights lawyer Mary Bonetto, Washington, D.C. lawyer Douglas Hallward Dramier, and U.S. Solicitor General Donald B. Verrilli, Jr. The states were represented by former Michigan Solicitor General John J. Bursch and Joseph R. Wallen, who was an Associate Solicitor General from Tennessee.
In the end, the majority opinion was authored by Justice Anthony Kennedy and was joined by Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan.
The dissenting opinions on the case came from Chief Justice John Roberts and Justices Antonin Scalia, Clarence Thomas, and Samuel Alito.
On June 26, 2015, the decision was revealed that the court held in a 5-4 decision that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. This overruled its previous decision in Baker v. Nelson, which ruled that the states did not need to acknowledge same-sex marriage.
After Obergefell v. Hodges, Flores and Bakers tried to deny gay couples services, but all of those cases were turned down, so none of them actually went to the Supreme Court, just the state Supreme Courts, where they were shut down immediately. And then some states like Texas and Kentucky tried to deny giving marriage licenses to couples, which was shut down by the Supreme Court. So ultimately, there haven't been any changes.
While no major court decisions have been made since the decision in 2015, in July 2016, the Republican National Convention condemned the verdict of Obergefell v. Hodges and called for its reversal on the grounds that it asserts the, quote, legitimate constitutional authority to define marriage as the union of one man and one woman. On the other hand, the Democratic National Convention later that same month praised the case for the equality it brought to the LGBT community. Smaller cases on the matter have occurred in the courts, as Abby said, regarding the discrimination against same-sex couples, but for the most part, these cases have not gone farther than their respective district or state courts. In fact, many conservative states, such as Alabama, have passed recent laws to prevent discrimination against same-sex couples as opposed to supporting it.
Obergefell v. Hodges was also a huge step forward in the fight for minority rights. By legalizing gay marriage, SCOTUS showed that the nation was willing to progress forward, and many people not only received the rights they deserved, but also received hope that rights for other minorities will improve in the future. LGBT communities began to focus their attention into other areas of civil rights, such as whether a business had the right to refuse service and which bathroom a trans person could use. Even so, the fight continues. Despite the ruling that it was not up to the state to determine the legitimacy of a same-sex marriage, some counties refuse to issue marriage licenses to gay couples even today. Many lower courts see the court cases being revisited constantly, and in general, many citizens of the United States continue to see gay marriage as unnatural. Still, the LGBT community remains prideful. Most of the nation is very accepting of the idea of same-sex marriage, and more people are comfortable with their sexual orientations. The media is gradually portraying more LGBT characters, and many famous actors and actresses are being unafraid to show their pride. Overall, this case has brought new life to the community, and it's hopefully a step forward towards a more accepting world.
Overall, I strongly agree with the court's decision. Under the 14th Amendment's Due Process Clause, I think that it extends over into marriage, so that basically marriage is a fundamental right. Also, I think the Constitution is a living, breathing document which should be interpreted. It's not the way it was when it was first written. And love is love, so do what you want.
I definitely agree with the court's decision, both for personal reasons and for the general validity of the decision. The state should not have a right to impede upon a citizen's inalienable rights, which includes the pursuit of happiness. Loving a member of your own sex is hardly different than loving a member of the opposite sex, so why should the marriage of one be legally recognized and not of the other? Marriage is a fundamental right, and bans on same-sex marriage clearly conflict with the Equal Protection Clause.
I think the court's decision was well overdue. In my opinion, and based off the Due Process Clause, there is absolutely no reason why gay marriage should ever have been an issue. As many cases have ruled, what one person does is his own business unless it harms another person, so why do we have to care what other people do? I think the court was simply upholding the Constitution with its ruling, as equality of marriage for all has been well overdue for a while now.